C'est donc la dernière table ronde de la...
Okay, will be the last roundtable of the day. How to fight against SLAPP, strategic lawsuits against public participation. And Christina Kruger will introduce this matter. Okay, good afternoon to all. I'm really glad to welcome you for this last roundtable of the day, devoted to the role of the lawyer again in the fight against SLAPP. And we're going to address a topic which is very up to date. It's this poursuite Bayon, this SLAPP issue, strategic lawsuit against public participation. Now, over the last years, we've been noting an increasing importance of the implementation of legal aspect proceedings, libel suits, to pressure groups that are of concern to us, that bother them, for just having criticized or having impacted their business. It could be journalists being pressured, NGOs, human rights defenders, any person having a role of vigilance, of criticism, of whistleblowing for the defense of public interests. And the goal, in fact, is to paralyze the action of such defenders by asking for extravagant compensations or to bring them into costly legal proceedings in which they have to ensure their own defense. And we are observing a disruption of the public sphere that goes into the legal sphere, and it's a real change in our own system, in our legal system, with attacks on the freedom to manifest. Now, the European instances have started to do something. In 2021, a work group has been published, a quick, small white book has been published. There was a public consultation that finished on the 10th of January, and the National Council of the Bars and also the European Council of the National Bars have been participating in this task group at the Commission level, and work so that lawyers are included as victims of these SLAPP proceedings, and not just through their clients. The European Parliament has also embraced the issue. On November 2021, there was a resolution for the protection of civil society, NGOs, with the definition of SLAPP, possible sanctions against these practices. The Council of Europe, the European Court of Human Rights, are embracing also these issues, but we note that the phenomenon is getting some more importance, and it's essential to continue the efforts against these initiatives. And we have here, for this roundtable, first-hand witnesses of what SLAPP brings and means. I will present them on the fly, but I would like to really thank the presence of Mr. Pawel. I hope I pronounced your name well enough. A Polish judge at the Regional Tribunal of Olsztynie, and is the first judge who wanted to challenge the legitimacy of the. You remember that there was this rule of the 19th of November 2019, and this desire of preserving the independence of justice brought sanctions on him, and I will leave the floor to him. And I do think also Hania GOUTIERRE, because Hania GOUTIERRE is going to provide a translation from Polish to French. And I thank you very much, Hania GOUTIERRE, for having accepted this mission. Mr. Judge, you have the floor. Good afternoon to all. I really do thank you very much for the possibility to come to Strasbourg and share my reflections, my thoughts. At the moment, the situation in Poland in terms of rule of law is really difficult. We have lots of problems. Since 2015, we have had a series of fundamental reforms. We have to wait for the translation in French, from Polish to French. And all these changes are not only contrary to the Polish constitution, but they are contrary to the fundamental principle of the rule of law in Europe and to the convention, the European Convention for Human Rights as well. Everything started with the dismantling of the Constitutional Court in Poland. I will be very brief, and I will say very simply that today in Poland, we do not have an independent constitutional court. The Constitutional Court today is composed of magistrates that have been illegally nominated by the powers in place and who have a sort of double qualification. They are persons who have been designated as replacement of people that had been elected or chosen by the competent bodies of the former political system. What's more, the President of the Constitutional Court has been illegally designated, and however, this is the person who can designate judges at all levels in the Polish judicial system. The European Court for Human Rights, in an ordinance against Poland, has clearly said that it says that the training of these judges illegally nominated by the powers at the Constitutional Court do not have a legal role and that their decisions should be considered void. But there is worse, and the worse is that the whole prosecutor's office in Poland is politicized, and all the members of this prosecutor's office are people under the direct influence of the Ministry of Justice. And I think that's one of the worst things that represents evil with a big E is the politicization of the National Judiciary Chamber, and that would be the equivalent, the National Judicial Council, that designate judges. According to the Polish Constitution, this National Judiciary Council has a twin composition with judges, legal practitioners, magistrates, but also political representatives. In March 2018, a change came with the designation of the magistrates within this body, starting to move towards the Polish parliament. And for practically the unanimity of legal practitioners in Poland, there was a blatant violation of the Polish constitution. Which is why the pseudo-elections that have been organized as a facade by the powers in place have been boycotted by the judges. The judges have refused to take part in this simulacra. Proof of it is that 18 persons have been candidates to the positions, these judge positions, where we have 10,000 judges in Poland. 18 candidates for 15 seats, which tells you the interest and the way things went. To add to all this, you have to know that one of the candidates could not, according to the text of this new law, could not collect the 25 signatures necessary to support his candidacy. According to me, but also according to some of my colleagues, we think that the persons sitting in this National Judiciary Council are not worthy of representing the legal practitioners in Poland. This court, let's call it court, this National Council, we have called it the Neo-Council, Neo-Court. This has entailed a reaction, and the reaction was that all nominations of judges in the courts of the country have been put into question again. And this is not just my own idea, my personnel will to bring this into question. It's also the position of the Association of Judges in Poland. It's an association that has been in existence for 30 years. It's very reputed in Poland, and most of the judges said that they would not acknowledge the nomination of these judges. What rejoiced us is that our position was comforted by the last year ordinances that have been rendered by the European judiciary system and the CEDH, the European Court for Human Rights. As regards the ordinances of the Court of Justice, which we as Polish judges and European judges have to apply,
przed Trybunałem Sprawiedliwości Unii Europejskiej, który to Trybunał wówczas już potwierdził, że zarówno Krajowa Rada Sądownictwa, jak i Izba Dyscyplinarna utworzona w Sądzie Najwyższym powinna być niezależna od władzy wykonawczej i ustawodawczej i nakazał polskim sądom badać okoliczności i wpływ tych okoliczności, tej niezależności, czy to KRS-u, czy Izby Dyscyplinarnej, na niezależność powołanych neosędziów.
So, what is interesting to note here in regards to this situation is that an important ordinance of Justice Court, 19th November 2019, this ordinance, AK, November 2019, considered that the court in question was not an independent body, independent in the sense of European texts and in particular the Convention, did not offer the necessary guarantees for the citizens, and as thus inclined the judges on each and every occasion to control the situation on the field. Each time they had to assess a given situation, the Justice Court said that they had to control whether the decision rendered by this body was rendered by an independent and impartial body.
Był Sąd Okręgowy w Olsztynie, w którego składzie ja jednoosobowo zasiadałem.
I was the first one to apply this ordinance of the Justice Court as a judge to the Tribunal of Olsztynie, and we had to render a sentence on such a case. It was up to me on an appeal procedure to evaluate a case that had been brought on appeal, something that had been judged by one of these neo-judges. And hence, I looked at the independence of the body which gave the first instance sentence. And so I have asked to the higher instances to supply to me the list of the signatures of the judge that had rendered this initial sentence.
Władze wykonawcze, ale i władze polskiego parlamentu ukrywały te listy, pomimo tego, że zapadły już wcześniej orzeczenia sądów administracyjnych, które stwierdzały, że jest to zwykła informacja publiczna, która powinna być upubliczniona, ujawniona wszystkim.
One has to know that at the time, the powers in place dissimulated the information about these lists and did not want to disclose such documents, even though there had been already decisions by administrative courts in Poland considering that disclosing such lists was public information and there was no difficulty in publicizing these lists.
Swoje postanowienie wydałem już następnego dnia po wydaniu wyroku TSUE.
My decision was rendered the day after when the Justice Court gave its sentence.
I w żaden sposób nieuzasadnioną decyzją odwołał mnie z delegacji z sądu okręgowego i de facto degradował do sądu niższej instancji.
5 days later, I received an information from the Ministry of Justice whereby I was revoked in my function of judge at the Tribunal of Olsztynie, and I was to be sent back to a lower instance court. The next day, I went to the media
Że prawo do stron do rzetelnego procesu jest dla mnie ważniejsze od mojej sytuacji zawodowej.
in which I said that the right to a fair trial for both parties was more important than my personal situation. I have indicated that a judge should not fear the world of politics, even when his or her career was at stake.
Pamiętali o rocie ślubowania sędziowskiego, orzekali niezawiśle i odważnie.
And I even invited my colleagues judges to do the same and to remind them of their oath to render justice in an impartial way.
Specjalny rzecznik dyscyplinarny powoływany po tych zmianach ustawodawczych wprowadzonych przez aktualnie rządzących postawił mi zarzuty dyscyplinarne.
2 days later, I received the visit of the Speaker of the Disciplinary Chamber notifying disciplinary proceedings against me.
Podstawowy zarzut, jaki mi postawiono, to, że miałem przekroczyć swoje uprawnienia, popełniając jednocześnie przestępstwo kryminalne.
The accusation was that I had come out of my functions and that I had committed a violation.
Dokumentu z Kancelarii Sejmu z tymi listami, tych list poparcia sędziowskich członków Rady Sądownictwa.
I'd like to remind that this accusation was just about my request for disclosing the 25 signatures.
Dyscyplinarny, że mówiąc te 3 zdania, między innymi o tym, że sędzia nie może bać się polityków,
And what's more, because I had pronounced the sentence saying that a judge should not fear the political world,
był takie wystąpienie skierować zdaniem władz tak zwaną drogą służbową, a nie wypowiadać się publicznie.
I should have gone to the higher instances before I would publicly address this situation.
Listopada prezes mojego sądu zawiesił mnie natychmiast na miesiąc we wszystkich prawach i obowiązkach jako sędziego.
The next day, 29th of November, the president of my court member of the KRS, the member of this Judiciary National Committee, suspended me for 1 month in my functions.
Prezes sądu zastosował w tym przypadku procedurę, która wcześniej była stosowana w nagłych wypadkach, kiedy łapano sędziego na gorącym uczynku popełnienia poważnego przestępstwa.
The President used for this an exceptional proceedings that we used in extremely rare occasions where indeed a judge could be accused of things that would make him or her unworthy of his function, like being drunk, or, you know, this is the sort of occasion in which these proceedings were used.
Jako przestępstwa zdeterminowało właściwość Izby Dyscyplinarnej.
The fact that my acts, my deeds were qualified as criminal entailed going to the disciplinary chamber.
Szczególnym organem powołanym przy Sądzie Najwyższym, w całości obsadzonym na wniosek NIORÉ przez osoby w dużej mierze wcześniej powiązane z ministrem sprawiedliwości.
And I'd like to recall for your information that the disciplinary chamber is only one emanation of this Judiciary National Council, where the people sitting there are members also of this KRS, so are neo-judges themselves. The Supreme Court, composed by magistrates that had been legally designated,
Wydali orzeczenia, z których stosując test zawarty w tym orzeczeniu TSUE z 19 listopada 2019 roku,
rendered a decision that I considered as a test following the decision of the former decision.
w tych orzeczeniach stwierdzili, że Rada Sądownictwa w Polsce nie jest niezależna.
And the court, quite in a courageous way, said that indeed the KRS was not an independent body,
Nie spełnia standardów i nie jest sądem w rozumieniu prawa polskiego, jak i prawa europejskiego.
and the disciplinary chamber has not the quality of a judiciary body and cannot render a sentence.
Najwyższy stwierdził też, że decyzje wydawane przez Izbę Dyscyplinarną nie były i nigdy nie będą mogły być ważnymi orzeczeniami mającymi moc prawną.
And what's more, the Supreme Court clearly said that any decision coming from such a body should not be considered as an executory decision.
4 lutego 2020 roku Izba Dyscyplinarna bezterminowo zawiesiła mnie w obowiązkach i prawach sędziego i odsunęła od orzekania.
Despite this, in February 2020, the disciplinary chamber took me out of my judge functions.
Przy czym żadne czynności w mojej sprawie dyscyplinarnej nie są podejmowane.
That situation is still ongoing. I am still suspended. I cannot be a judge at the moment. And one should know that for the last 2 years, nothing has moved in my case.
Trafił po ponad roku ale znowu tej nielegalnej Izby Dyscyplinarnej.
The requisitory about me came in the disciplinary chamber 1 year later, and since that time, nothing.
Oczywiście złożyłem skargę do Europejskiego Trybunału Praw Człowieka.
You can imagine that I seized, of course, the European Court of Human Rights. And this case is being instructed. The Polish government is informed of this.
Podjąłem też próbę walki środkami prawnymi.
Internally, I have also tried to counter these decisions through domestic law in Poland.
Profesor Uniwersytetu Warszawskiego, jednocześnie adwokat reprezentujący mnie, wytoczył dwie akcje. Z jednej strony skorzystał ze ścieżki prawa pracy, a z drugiej strony ze ścieżki ochrony dóbr osobistych.
Un éminent professeur.
So I have a professor of law in Warsaw, highly reputed, who is acting on two ways. On the one side, in the labor code aspect, and as a second is the confiscation of goods.
Dwa orzeczenia w dwóch oddzielnych tych sprawach, korzystne dla mnie jedno i drugie, nakazujące natychmiastowe przywrócenie mnie do praw sędziego.
Let me summarize this in a simple way. In both cases, two positive decisions in my favor, reintegrating me as a judge in the Polish judicial system. At least there are decisions that don't yet have the character of the judged case, but they exist. Despite this, the president of the tribunal where I sit refuses to execute these decisions.
Prezes sądu, który nie wykonuje prawomocnych orzeczeń sądowych, jest jednocześnie członkiem tej Krajowej Rady Sądownictwa i to tym członkiem, co do którego już teraz wiemy, że członek ten nie uzyskał wymaganej nawet ustawą liczby poparcia głosów w środowisku sędziowskim.
As a wonderful paradox, I would tell you that this president who refuses my integration sits at the KRS, this National Judiciary Council, but is also the person who could not collect the 25 signatures.
Decyzji prezesa również nie zmieniły orzeczenia Trybunału Sprawiedliwości Unii Europejskiej z 14 i 15 lipca 2021 roku, które już przesądziły całkowicie, jednoznacznie, że Izba Dyscyplinarna nie jest sądem i że jakakolwiek działalność Izby Dyscyplinarnej powinna w Polsce ulec wstrzymaniu, a nie została wstrzymana i kolejni sędziowie są zawieszani.
The said president was not influenced either by the fact that the European Court of Justice has rendered two other decisions in 2021, which quite univocally said that these bodies were illegally constituted bodies, that they did not have the nature of a judicial body in a position to render independent justice decisions. Well, he just ignored these two decisions.
Moi koledzy z sądu, wzywający prezesa, by dopuścił mnie do orzekania na oczach nas wszystkich sędziów, bo działo się to podczas zebrania i w świetle kamer, które prezes zaprosił.
What was pathetic here is that this president of the court at some point invited the media and it quite ostensibly tore down the decisions of the Court of Justice.
Były zgłaszane do prokuratury. Zniszczenie dokumentów.
All these acts have been denounced at the prosecutor's office level. The fact that you tear down official documents in public, in particular, the violation of the labor code, preventing an employee from operating in his trade, the impossibility to execute a decisions.
Wszystkie te zawiadomienia, na skutek tych zawiadomień prokuratura, tak jak wspomniałem, musicie mieć Państwo świadomość tego, upolityczniona prokuratura odmówiła wszczęcia śledztwa.
Despite these demands that were directed to the prosecutor's office, remember what I said before, we have a prosecutor's office that is totally politicized, and of course the prosecutor's office did not start any proceedings in this case.
Zażądali akt sprawy, w tej pracowniczej sprawy, w której zapadło orzeczenie w trybie zabezpieczenia o nakazaniu dopuszczenia mnie natychmiast do orzekania.
The representative of the disciplinary chamber required that he receives the decisions concerning the return of Pawel in his function as a judge. Although that decision is not yet enacted,
Specjalny Wydział Spraw Wewnętrznych Prokuratury Krajowej, tego najwyższego szczebla w hierarchii prokuratury.
in parallel to this, a special service created within the Judiciary Prosecutor's Office in charge of these politicized cases has requested that we send to him this information, which of course for us was a blatant manifestation of the pressures that the prosecutor's office wanted to bring on the decision. New pressures from the prosecutor's office, from the judges, deciding on the appeal of Pawel. They said that if a decision contrary to theirs would be rendered, then there would be criminal proceedings in the case. The Professor Romanowski decided to inform the European instances of this situation. It was a mistake he made in his letter because he designated another representative of the disciplinary chamber than the one in charge of the case. And this person has introduced an action, a libel proceeding, even though he himself, this representative of the disciplinary chamber, has himself committed such acts, that is, requests documents under pressure. I know I don't have much more time to explain this. I could give you examples ad lib. I am not the only one. I have many colleagues who are submitted to such proceedings.
W kontekście SLAPP w Polsce w tej chwili obowiązuje ustawa kagańcowa, która ustawowo zakazuje sędziom badać, czy obywatel w Polsce ma zagwarantowane prawo do niezawisłego, bezstronnego sądu i rzetelnego procesu.
Just to finish and to conclude on this SLAPP issue, you should know that in Poland there exists a new law, SLAPP law, Loi Bayon, which prevents us legal practitioners, and in particular the judges, to check the impartiality and the independence of the bodies that render the decisions. Which is why, for me, of course, the return to the rule of law in Poland is a fundamental issue. We, the European judges, are on the forefront of the defense of civil liberties. We pay a high price, but we're ready to pay it, and we count on your support. Thank you very much.
Yes, I would like to react to what has just been said. As witness, I think we all so much touched by all what you said. Thanks for what you said. It's an illustration of how this action of intimidation can go far and terrible they are. And we can see that the European institution here can be a sort of a wall, can be a support. And the European jurisdiction don't close their eyes. And I think, before all, you understood it, that you manifested a lot of courage and to combat this type of attitudes, you know, what you need is courage. And I would like now to move to my colleague Vincent NIORÉ. We know his engagement, and I'd like to give him the floor. Thanks a lot, Miss Christina. It's a beautiful day. It's a great day. Thanks, Laurent. I have a great man at my side and an unbelievable magistrate with a lot of courage. It's impressive. And this makes me think of the formula of Robert Badinter for a lawyer. Courage is the most essential thing, because without courage, talent doesn't count. And I was very happy to hear him say, a judge must not be afraid about politicians. A judge doesn't have to take account about the politicians. If he has to worry about his career, we can say the same about the lawyers. And under the control of Ms. Couturier, our friend, Pawel, JUSZCZYSZYN, yes. You can confirm he is invited to our day on the 10th of February at La Maison du Barreau, who will be our guest. Yes, yeah, what we want to say, what he said makes us think of a personal experience I had when I was president of the bar. What is the judicial intimidation in France? Judicial intimidation is not only the fact due by a government. It can be a lawyer, which is making complaint from launch a complaint against another lawyer. It's a persecution that is consecutive to the fact that you have launched a complaint. So the rule of law in France allows this way of lodging complaints. And what is important in this game of actors is the role of the president of the bar. After the Chamber of Cassation has made a definition of this, and you know, the criminal chamber is publishing books, and in '75, I said it already, this is particularly true when we hear the witness of our friend Pawel today is the president of the bar, Payen, in his book, which was our guide at that time in the 80s, which gave a definition of the president of the bar when the fact of perquisition, the professional secret and protection against seizures. Nobody did anything about it until the criminal chamber, after it has not been received by the criminal chamber in 2003. The president of the bar is not part of the procedure, but it consecrated him as a stakeholder of justice, protection of defense, when there was a perquisition, a search. And this is our independence, which is touched here, our DNA, so to speak. And the jurisprudence at that time, with the audience in front of the judge about the contestation about perquisitions, this had led to different incidents, disciplinary pursuit by a prosecutor that felt outraged. The audience was secret, and many actually lawyers cried, and I have seen that many magistrates made the lawyers cry. This. So the defense of professional secret was not respected. So the prosecutor has here to keep secret the rights of the defense. So what is interesting here is the intimidation can come from the government, it can come from a complaint of a lawyer, it can come from a magistrate, general prosecutor is losing his nerves, and so you can, in the description of this judge, which is causing trouble to our friend, but in France it's different. It's home of the human rights, so to speak. So you can always say the arbitrator's lawyer, it's normal that he can be prosecuted because he has not respected his obligations. So the notion of courage again, that Batten there in the affaire Bontemps mentioned, there are some pieces he could not produce during the debates. He takes the risk and he says, nevertheless, I had to do it. And his client is nevertheless condemned to death, but he did it. So there's a transgressive defense, like in Poland in this case. And I can say I find myself in the portrait that was made by in the description of the case we have just heard about. So today we fight. What for? I remember the role of the President of our. Sorry if I'm a bit too long. Give me just another minute, please. I wanted to say we fought recently. What for? With the conference of the President of the Bars, with the reform of professional secret about the system of the search in France, perquisitions, in the lawyer's offices. What for? Because so that the President of the Bar is present in the case of corruption and so on, that he is still here for not as complicity, just about the because it's important to have very strong rights for the defense. We fought. I didn't calculate the hours I spent to make the reality is self-evident. And what I want to say is that the lawyer's office have discovered the secrets are not always kept secret in the law firms, so to speak. So it's not professional secret, they say, and the document will be presented to the procedure for the defense. So decisions generally are still given according to this. So we still have a work to keep things secret, that the secret should be preserved. Our role today is to repeat what is self-evident, and so we have to repeat and repeat the same things again. So the answer to this intimidation has to be done on a judicial way. I answer questions that have been asked later. I had a criminal reaction. We have to react in front of CSZN, faced to this illegal interest. We speak about this muzzling the defense, having lawsuits for muzzling lawyers and the citizen. So for himself and for himself, not for the other magistrates. The other magistrate didn't want to have disciplinary procedures, but only against him because he exercised his power. If the same circumstance would happen again, we would have to replicate brutally, even on the judicial level. We will not change the formula, and I'm comforted in that. This is my last sentence. I'm comforted as our friends give us our witnesses. In France, we have courageous magistrates as well that want to preserve their independence and our lives. Not all of them, of course. You have a crisis of justice. I don't speak about this recent crisis we have. I speak at the preservation of professional secret. We have the just of liberty and detention, which lawyers have to suffer from. Magistrate at the siege, they wanted to protect the profession of the lawyer as far as the secret of counseling is concerned, and the exercise of the defense when the president of the audience supports me to witness in my favor and saying that I was in my road as a lawyer. So you see, sometimes the magistrate is helping, supporting the defense. So we will be here to avoid all these exaggerations with Judy, President of the bar, then in the dialogue with the magistrates, because these people are the same people as those that are giving you hands, smiling to you, and then we have to work on a dialogue to normalize our relations. And if we have to have a common interest dialogue, it must be on the basis of the respect of the professional secret in reality, in practice. And this is the most important point in our relations with them, with the magistrate. I was a little bit too long, sorry about that. No, yeah, we're never too long on this type of subject. Maybe we can make a link with what our Judge Miomar said this morning, which spoke about this unicity of the professional secret. And I think we are here in subjects which are essential at the heart of the matter, so to speak. We have to fight. So I turn myself towards now Matthieu BOISSAVY from the CNB. Matthieu, I give you the floor. BOISSAVY, lawyer at the Barreau de Paris, Vice President, the Commission Libertés, Droits. Thanks for this beautiful day that you have organized. Thank you to the President of the Bar of Paris and Bruno Blanquer of the conference of the Bar, and speak in my name and in the name of the National Council of the Bar and Mr. the Judge Pawel, JUSZCZYSZYN. I would like to say to all you that how much I am, what you have told us has had a print on us. We would like to follow your affair. We want to follow you. We want to see what happens with you. And I want to inform everybody that with the authorization of Laurent Baum, we are going to invite you. We are going to organize a hearing at the Human Rights Association. They have already taken a resolution, actually, a few months ago, about the state of the law in Poland. And we are going to look at your dossier, in your file. Let's go even further. I know that the Professional Association of the Magistrate in France heard about your affair already. They are mobilizing in the framework of Magistrates in Danger. We are defending magistrates in danger everywhere in the world. Turkey, for example. These professional associations have to mobilize themselves. And I'm going to speak about it to a certain number of magistrates in these organizations, so they get aware of your affair and the appeal that you can make. We will not let it down. So it's an illustration, terrible illustration about judicial intimidation. Judicial intimidation, you ask, what is it exactly? Just to, for those that spoke about it, the American and people from Quebec, how can an action in justice, can it, the instrument, the object of an injustice, how a judicial debate can it have as a goal not the search of the truth between actors which have different pretensions, but just to harass, to ruin even sometimes people, discourage people, and make the intimidate the adverse party. So the abuses, how is it possible to allow this? This is the object of our debate on the subject of these judicial intimidation, what the Americans denounce as slaps. Slap, when you slap, is when somebody slaps you on your face, gives you a slap, which of course it means strategic lawsuit against public participation. But it's, you think about a slap, give you a slap, what we call poursuite bâillon, which is lawsuit to muzzle citizens. You act against somebody so it can't speak anymore. You intimidate him, you muzzle him. So this concept actually appeared in Canada, North America, after lawsuits we saw in France, beginning of the year 2000. What are the circumstances, characteristic of this type of pursuits, procedures, action about problem, general problem, which is public debate, which gives, originally, I will give you some illustrations. It leads to a procedure engaged by a company, an organization, strong organization which has financial means to do it, and destined against a journalist, for instance, an association, an organization, human rights association, for instance, somebody that is speaking and protests in front of a situation against the company. So judicial procedure engaged between these actors, and which has as an object to ask for sanctions, criminal sanctions, or asking for damages, high level, or to launch multiple procedures, expensive procedures, to exercise pressure and psychologically or financially ruin the person that is making the complaint. So, what are the basis, judicial basis? We have defamation, slander, or denigration, and we have as well. As far I give you example of two affairs in 2003 and 2008. It's a big company, oil in the oil sector, against Greenpeace. It was, I think, and Greenpeace had hired a protest campaign against this company and had used logo, icons of this company. And this company acted, it's called counterfeiting. And there was a company, and the other one was in the nuclear sector. And the Court of Appeal has realized, well, wait a moment, okay, it has to say used your icon, your logo, on which you have a property, but it was not to create a confusion. But so what is important for us is the liberty of speech, freedom of speech. So second type of affair to denigrate. You had same case, more or less, an activist which it was against a company producing guns, electric guns. An association had denounced this product, protested against the fact that this product is dangerous. And the company said, wait a moment, you are denigrating us. When you are denigrating, you discredit a product or a service. This was the fundamental Article 140. And here again, the French jurisdiction said, no, this, okay, there is a denigration, but it's pronounced not by a competitor, but for the good of the people, which is of general interest. And so it's a liberty of expression, which is here important, and not the fact that you are feeling denigrated. And you have defamation. That's the most current one. There's an affair which I know very well. I was the lawyer actually in this affair. This affair appeared in the press. There are many articles about that, which talk about that. This led to an action of the Ministry for Research. Defamation. Yeah. It was actually about a law professor who made a comment about a judgment which condemned companies for pollution. An appeal was made against this decision, but before the Court of Appeal made the decision, the law professor had made a comment about this decision of the justice, and the companies that had been condemned for pollution made actually a complaint about libel, slander, defamation. And they said I say what it's meant by defamation is when you accuse somebody against the fact or the consideration or the honor of somebody, and when you say to somebody he has made a criminal offense, of course you attack his honor. The company said, you said in your comment that the decision is that it is a defamation, the libel suit, and this left to big emission. And then I was speaking about here a lawsuit to muzzle a plaint with the procedure which is in defamation. There is a particular procedure in the instruction. In France, again, there is an automaticity of mise en examen. So the juge, the judge, cannot, it's very rare to say that he can say, I consider that there is no reason to make pursuit, to launch a procedure. No, he has to do it. He has, and it's the Court of Justice that takes the decision in the end. So, actually, it is evident that the civil parties, juge d'instruction had to be confronted with, so the professor was under a procedure. So you can... the Court of Justice has they simply said, okay, they're free because they didn't mean any bad things at the invocation. So the Court of Appeal, I forgot to say it, the court condemned the civil parties for damages for abusive proceedings. And what is remarkable is that the Court of Appeal has confirmed the judgment and said, but on a different basis. It has estimated, I give you the motivation, can be useful in the case of suit for muzzling. It has considered that it didn't want to see if there was defamation or not, and for the following motive: as soon as person animosity is not implied against the moral or physical person, or the or words which has nothing to do with the cause, you will have to remember that notion, because we will have to see it in the law from 181, when there is no wording which are nothing to do with the cause, which if there is no person animosity about the people that are the complaint is about, the fact that there is an article like this is an attack on the liberty of expression for the professor. So this is why it's relaxed, is considered free, and the condemnation have been confirmed. And so you see, I wanted just to tell you, give you a few examples. I'll leave you work with some. I will evoke some proposition under the direction of Mr. Mazzo, which inspired the work on this subject. So, you asked me, in how far can the lawyers be attacked or be intimidated judicially in France?
Well, the lawyers, in their defense activities, when we protect and defend our clients, we have pressures that are exerted on us from the media, but also sometimes from the judiciary system under different formats, disciplinary action sometimes, civil proceedings from the adversaries of our clients, and also sometimes from the public authorities. And the activities of the case of Pawel is one such issue. And what can we do in libel cases, and also cases where the violation of the professional secrecy has been committed? The trust law that was last voted in December 2021 entails that disciplinary actions can be larger because the third parties are not maybe just the clients or adversaries of our clients, but it could be third parties, it could be anybody else, it could be any other entity. It would be the case law to define exactly what it is. These third parties could complain to the bar. If the president of the bar doesn't open a disciplinary sanction, that third party can claim to the prosecutor's office, and if the prosecutor's office doesn't do anything, then that third party can seize directly the disciplinary body. So let's not doubt, dear colleagues, that we are going to see flourish actions and proceedings abusive proceedings and ill-founded proceedings, and unfortunately there are no efficient sanctions against such proceedings. Yes, there can be a dry answer given to a proceedings that would be ill-founded, but there is no real recourse, no real sanction against that. I have maybe a few. Okay. Let me finish. Okay, let me finish. How can we defend against these things? Against those abusive proceedings, expecting this new legislation, because we are expecting this new European legislation. For lawyers, we have the protection of the Article 41, and with the judiciary immunity, we have this protection, we have this immunity, and I hope that the case law of the Court of Cassation will change, because the law specifically says that the disciplinary sanction is a sanction, but we know today that even though the lawyer is protected from civil or criminal proceedings before the courts, it remains that the Court of Cassation judges that this immunity doesn't apply to disciplinary sanctions, contrary to the Conseil d'État. I hope that this case law will evolve in the future, but that's something else. So how can we defend against such abusive proceedings? I mentioned before, when you attack the libel, there's the exception of truth, there's the bona fide, there's the conventional demands, the article of the criminal code for abusive proceedings. There's the article 32-1 of the civil procedure code to request a civil sanction of 10,000 euros maximum without prejudice of possible damages. But you also have, and let's not forget, the Article 434-8 of the Criminal Code, saying that any act of intimidation towards a magistrate or a lawyer trying to influence his or her behavior can be punished 3 years of imprisonment and 75,000 euros sanctions. Is a SLAPP proceeding is it constitutive of an intimidation such as this article defines? I think it can be sustained, but it could be otherwise. It could be debated. So maybe we should think about a specific violation. You also have the Article 226-6, calumnious libel, but here again you have to demonstrate that the party claiming against the lawyer has done it in a conscious way. So the door is narrow here to invoke that article. Also, we have the Article 800-2 Criminal Code with the new law, 22nd December 2021, which enables you, in some cases, that the civil parties be condemned to pay the costs of the trial. And that's important because we didn't have this before. There's the same thing as the Article 75, but with this Article 800-2, you can ask for the civil party to pay for the trial costs and the lawyer's fees. And last, we will have to look at perhaps we should have a specific legislation, typically like the one adopted for the whistleblowers in the Sapin II law, and in particular the possibility for the judge to dismiss the case when the proceedings against whistleblowers are ill-founded and pronounce sanctions. So this is what I wanted to say on this topic, Mrs. President of the Bar. Thank you very much for this very complete list of possibilities and this perspective study. There are possibilities, there are recourses and ways to sanction these abuses, and this is to be developed, but that means that we have some instruments, some tools already in our judicial system. I now turn to Hania GOUTIERRE. Hania GOUTIERRE was an interpreter just before, but Hania GOUTIERRE can also bring a personal experience. You are the honorary president of the Chamber of Commerce of Poland in France. So again, you have perhaps an experience to share as a lawyer in these matters in terms of slapping and perhaps some differences. And you've been able to observe differences between Poland and France. Well, thank you very much, Mrs. the President of the Bar. Thank you again for this invitation. I will be extremely brief because I will just try to complete what Pawel said a moment ago. Indeed, I have some experience of this cross-border work between France and Poland, and I'd like to give you some element of perspective from the lawyer's point of view. We are talking about SLAPP, intimidation here, and to complete what Pawel said, the unfortunate fate of judges in Poland, to also talk about lawyers. You have seen that the political system in Poland is an authoritarian and populist regime that violates the fundamental rights, and the power tries to control all spheres of public life, and in particular the courts, that they want to influence and control the administration and the media. And we'll talk about the media later. These acts are unthinkable, but it's become a day-to-day thing now in Poland. You have to know that intimidation in view of denunciation and of citizens, because there's a split in the Polish society in Poland. You talk about those who are on our side and on the other side. It's really a split of the society, and these denunciations for political issues are really a day-to-day issue now in Poland. I've lived this with some of my clients who have been intimidated from people just coming in to visit and saying, hey, if you say this or that, you will not be annoyed. We know very well that you are not on our side, but if you give us such and such information, or if you say this or that, we will leave you alone. I have seen this, I've lived this. I've also seen pressures to obtain admission confessions under pressure. This is unacceptable. You have eavesdropping. We are concerned by this in France, but you have to know that lawyers in Poland are eavesdropped on a regular basis. It's extremely worrying. But I have some very classical cases today in Warsaw where lawyers are, and in particular lawyers who are active to defend persons like Pawel, judges, and these lawyers are eavesdropped. There are also some other intimidations, confiscation, arbitrary confiscation of assets, economic pressure, that's what I call it, economic pressure. So Pawel mentioned this before. It's really common now in Poland as a means of pressuring the citizens. The worst is that all this is happening under the diktat of the prosecutor's offices, and that act unpunished. unchallenged. I have here to say that I have, how should I say, I'm tired, excuse me. I really have to acknowledge the immense courage of my Polish comrades and colleagues, because they really sustained a fundamental role in 1981. Remember how the Polish magistrates defended the strikers in Solidarność, and it's really this momentum that we had in the 1980s is enjoying a surge nowadays. The lawyers have really gone on the sides of those who defend European and democratic liberties through the creation of associations. I would cite only one association in which I am engaged, Wolne Sądy, that means free courts, free tribunals. A large number of lawyers have engaged in this association to defend the judges submitted to disciplinary proceedings, and those lawyers are here to defend Pawel and colleagues, and the colleagues of Pawel. That's what Pawel said. Pawel was the first one, but other judges are being prosecuted. There is also a defense of some colleagues that have been deprived of some rights with disciplinary sanctions. We are awaiting some, the suspension is not yet pronounced, but it's quite possible that it will come up. And if that is the case, we will have to do something at the European bar level, because this is Poland, this is Europe. We have the Justicia Association, a very old association of judges in Poland that has taken a lot of importance and is really committed in the defense of judges like Pawel. And we have also the KOS, Committee for the Defense of Tribunals, of course, bringing together 14 associations with one-shot actions and more general defending actions for the values of the European rule of law. The idea is to have the decisions rendered by some non-acknowledged bodies to consider them as void, thanks to the CEDH rules, for example. The second is to define some common issues for the defense bodies. We try to look at the judicial foundings of the decisions so that we can bring something together that is sustainable, protest against pressures and eavesdroppings, and bring to the media all this on independent platforms. I talked about the hands of the power on clawing down the media. There's still one independent organ, TVN. TVN is a Polish channel, the last defense, where you can still find some non-state validated information. And it's really, this TVN is targeted by the powers in place. I won't say more. We also have lots of independent press bodies, organs, via internet, and that association has decided to bring to the media what happens on these platforms. The reason is, for the ordinary citizen, the whole thing, the whole shebang about the constitutional court, the conflicts between judges, they don't apprehend, they don't comprehend what this is. It's difficult to bring to the ordinary citizen what the stakes are. And so the Polish are genius people. You remember that there was this, there was the Polish plumber coming to Europe to fix the networks in Europe. Well, lawyers, published lawyers, are really talented as well, because they've decided to shoot some quick videos, actually many of them, on how the impact of independent judiciary system, what is the impact of that on the ordinary lives of citizens. So they've they've shot some small scenes of the day-to-day life. For example, you have a litigation with your neighbor, and if you end up with a judge that is a friend of the neighbor because they're in the same political party, they're on the same side, then they would have a contradictory, unfavorable decision. So these little videos really show how important it is to fight the systems. And these quick videos have had an enormous impact on the awareness of the public audience. And public awareness is very important to gain the trust of civil society. Really, as I said, the Polish society is really split, and it's not black-white. It's really sometimes soft. The political climate is changing, is evolving, it's on moving grounds. But this awareness of the civil society on fundamental values, because 85% of the population wants to stay in the European Union. I don't think that Pawel will share my point of view. I don't think Poland is ready for a Pole exit, but today it would be too big a risk for Poland to do a Pole exit, at least on the short term. We don't believe it. But we have to mobilize, in any case, we have to mobilize the opponents of the system. At the moment, Polish lawyers, and I will move quickly on that, have a big challenge. You remember that the the Justice Court of the European Union has brought decisions on that. Imagine the position of Polish lawyers. On the one side, they should refuse to be submitted to the judicial decisions that are not legally constituted. On the other side, we as lawyers are also here to defend the interests of our client. So we have this dichotomy. What should we do? Should we put everything into question with the risk of it going into obscure, abscons, judiciary proceedings with systematic putting into question before the CEDH? Or do we respect the desire of our client to get a quick decision? I could go at length on this, be it the right of the family for a simple divorce, a commercial litigation. We have really an issue on this. What do we do? What is important? Is it the rule of law or is it the interest of the client? I don't have an answer. I don't have an answer. It's really up to any one of us to decide in its own right and conscience. Now, for the future, it's difficult to predict the future. With Pawel, we together and other people around us are engaged in this battle. We are optimistic. Polish people are optimistic people. Solidarność came up after how many decades of communist rules? I don't remember, but we think people will change as quickly as possible, as quickly as we can hope. But it shouldn't be done at the expense of, with a trade-off. We cannot afford, Poland, to accept trade-offs, compromises. It's very important to not concede and not concede on fundamental values. Remember that, because it's an open door to anything can happen. And if a new power arrives in Poland, and should they say, oh, maybe we should forget, maybe we should put that aside in order for the society not to be split again. No, let's not cede on that. Let's not concede anything. That's my opinion. As for the expectations of Polish lawyers, they expect your support, yes. Their situation should be brought to the media in Poland and elsewhere. And they also think that the sanctions, as they are applied by the European Union, they are of the opinion that these sanctions can have an effect, hitting the wallet of the people. It's unfortunate, but it can have an effect. It's really unfortunate because it's the future of the development of Poland that might suffer from this financial sanctions. But maybe there will be a way to pressure Poland to change. 32 years since '89, the liberation of Poland. And just to finish on this note, let's remind, nothing is never acquired forever. Democracy is fragile. In 2014, I had invited to the bar of Paris Lech Walesa. We were rejoicing, we were feasting the 25 years of liberation of Poland, this economic growth, everything that happened. 32 years after that, I have doubts, and I'm very sad with what's happening in my country, in my own country. Let's rescue the state of law, the rule of law, and to finish, perhaps I'd like to quote a little sentence, a little phrase that Pawel said to me, and he authorized me to quote. He said, I would like to see an health commandment. Do not be indifferent. Thank you.
Merci beaucoup, Hania.
Oh, thank you very much, Hania, for this testimony and yes, this experience and bringing in perspective this duty of care, this diligence and this cooperation and action requisite so that this European space remains based on democracy and the values that found our democracies and the rule of law in Europe. I now turn to, because we don't forget that if the freedom of press, if the freedom of opinion is buffooned, then journalists are a target. I'm very happy to welcome Paul Copin, responsible for legal affairs at Reporters Sans Frontières, Reporters Without Borders. And Mr. Copin, you have the floor for the position of the journalists on this. Thank you very much for this invitation. Indeed, Reporters Without Borders, or those who don't know us, is an organization defending the independence, pluralism, and freedom of the press and journalists and all those who incarnate these freedoms, the journalists. Now, many journalists throughout the world are confronted to abusive procedures, intimidation procedures, in Europe, in France, everywhere in the world. And many studies tend to show that the trend is aggravating. The commissioner to the human rights in Europe had said that the phenomenon is getting more and more serious. Now, let's underline that all procedures are not abusive. Journalists have to be responsible for what they write, what they say. The freedom to say is not an absolute right. It has some limitations. If you consider that your rights have been buffooned by a publication, so Reporters Without Borders is not keen to say that all those who try to restrain the freedom of journalists are ill-intended. You have to find the right balance between the rights of the individuals, reputation of individuals, the right to act in justice, and on the other side, freedom of speech. Once you've said that, we can observe a very large number of proceedings based on intimidation because of the work of journalists, proceedings that are engaged by individuals, corporations, public entities, proceedings that are disguised as trying to defend the right of the individual or the body, but in fact, that really try to intimidate the journalists, to dissuade the journalists, to investigate, to dissuade an investigation on the case that might be, with possible liquidation damages that might be very important, exorbitant, and really with very lengthy proceedings that may entail extremely high lawyers' fees, travel fees, even though the journalist in the end will not be condemned. Just the idea here is to silence the journalist, to prevent him or her to express something on the individual or the entity. And this is really an abuse of rights. But they're not going to the justice to get acknowledged a violation, but it's just using the justice to silence journalists, which is something different. And today, it seems that these SLAPP procedures have become the favorite weapon of the rich and powerful to dissuade, to retaliate against all those who investigate on them and say something about them. Very often, journalists are not condemned. The judges acknowledge the seriousness of the investigation, the public interest expressed by this investigation, but the wrongdoings have been done. It's too late. The risk is not the risk of being condemned, even though that might be the case, where in some countries the justice is not exactly independent, so corrupted sometimes. But even before the risk of being condemned, you have the risk of obliging the journalist to devote energy, time, money to organize his or her defense, and time and resources that will not be devoted to the investigations he or she wants to conduct. And it can really kill the media. It can really kill journalism, which is very worrying at a time where the journalism position is becoming more precarious, and the financial situation of some media organs is very fragile. So these SLAPP procedures are very efficient to silence journalism, and the problem, it's a problem for journalism and for the media, but also for the right of the public to information. It's really, in the end, the right of the public, the population, to have access to information. So it's a real issue for democracy. Now, I won't be too long on this, but I cannot give you an exhaustive list of all the abusive proceedings against journalism. There are cases everywhere, in France, in Germany, Sweden, Germany, Slovenia, Bulgaria. I can give you a couple of examples. This morning I was asked to read a press release that we're going to publish today or tomorrow. Cases in Bulgaria. 2 journalists being prosecuted for offense to a judge for having published on the sort of side actions of a magistrate, and sentenced to 30,000 euros, which is going to kill this press organ. In another case, it's a Bulgarian media condemned to 500,000 euros for investigating on an investment company. So these are extreme high risks. There's, of course, the Denis Robert example, and he was investigating on the Clearstream affair in France. And for 10 years, he had 63 judicial proceedings for injury, libel. It took 10 years out of his life. It cost him tens of thousands of euros. And at the end, he was released, freely released. But for 10 years, he had nothing else to do than defend himself, and the psychological impact that can have on somebody trying to bring a serious investigation to the public and being harassed with all possible means. It can really discourage journalism, and you have to be as obstinated as Denis Robert to continue this work. The journalist of Malta, who was assassinated in October 2017, she had 47 libel proceedings from the former prime minister and next of kin to the prime minister, and a specificity of the law in Malta. This is continuing to proceed to the heirs of this journalist. In Poland, this newspaper that is very critical of the powers in place, 55 proceedings by a number of actors from the people next to the power. And last but not least, I cannot mention the champion, all categories, the Vincent Bolloré. Vincent Bolloré, this French industrial leader, and his practice, the attack against journalism, as a whoever investigates on him, it's systematic. You're being harassed by, since 2019, it's about 50 journalists, but also photographs, NGOs, who have been sued by Vincent Bolloré for harassing, for a number of things. There was a contradictory things, you know, even if you call Vincent Bolloré before to get the observations of Vincent Bolloré on the contents of the article, so you try to join Vincent Bolloré with SMS, with telephone, and even before the article was published, Vincent Bolloré attacked for harassment. And a recent example for Vincent Bolloré, RSF, Reporters Without Borders, the system B was proposed, a B system in which a former journalist of Canal Plus belonging to Bolloré, Jean-Marie Rivoire, described the management methods of Vincent Bolloré. Jean-Marie Rivoire was attacked by one of the companies of Mr. Bolloré before the Président, the Labor Code Judicial Authority. So Mr. Vincent Bolloré is very imaginative when it comes to attacking journalists. And so legal proceedings against journalists are extremely numerous wherever the resources for journalists to protect themselves are insufficient. The resources to dissuade those who try to do that are largely insufficient, and I think it will be a follow-up on our discussion, and I thank you very much. Thank you very much. We shall conclude this roundtable. We have seen the seriousness of this issue of judicial intimidation through several testimonies. I think it's quite compelling, and also the necessity of not being indifferent, as our colleague Hania GOUTIERRE said, and try to contribute that Europe continues to develop tools against this. I thank you very much all for your attention. Thank you very much.